May I proceed?
You may.
Thank you, Your Honor. Following the law, I heard Ms. Holmes say that at least a couple of times. Following the law, well, I'll say this. Following the law was a completely foreign concept to Laquan McDonald. Based on all the evidence in this court, I can't think of one law Laquan McDonald followed. And they don't address that, Judge. They don't talk about it, Judge. They don't talk about Laquan McDonald's crimes. They gloss over if they even mention that he had a knife. They completely ignore Rudy Barillas. They don't talk about him. They don't highlight his name on police reports. They refuse to accept that Officer Gaffney is a victim of an aggravated assault, a felony, a forcible felony. They refuse to accept that Officer McElligott is following this armed offender for blocks. And he continuously asks, he demands, he pleads with McDonald to stop and drop the knife. McDonald ignores all of those commands. The prosecution doesn't want to talk about that. Well, the police officers out there that night, they can't afford to ignore it. This case isn't about violating public trust. It's about McDonald violating the laws. It's about law and order. Thank God we're in a courtroom. Thank God we are in a courtroom, finally. Finally. A courtroom where evidence matters. Not outside noise, not misinformation. Evidence matters here. Not labels promoted by people that weren't there. We keep hearing labels like false reports, false reports, false reports. They're hoping that the more times they say that, you'll believe it. But I know, Your Honor, that you're basing your decision on evidence. Evidence. Witnesses that came into the courtroom, swore to tell the truth, and were subjected to cross-examination. I wish Ms. Holmes could name one witness on October 20th, or even the next day, on October 21st, who told David March that Laquan McDonald was not an armed offender. Is there anybody that wants to say Laquan wasn't armed that night? Thank God we're in a courtroom. Thank God we're in a courtroom where there is a presumption of innocence attached to every defendant in every criminal courtroom. I told you at the beginning of this trial, and I'm telling you again, Dave March is not just presumed innocent, he actually is. And thank God we're in a courtroom where the burden of proof is the highest in the land, and that they must, without limitation, prove to you beyond a reasonable doubt the guilt of all defendants in this case. That evidence must be strong. It must be clear. It must be unambiguous. It must be compelling to convince you beyond a reasonable doubt. Close equals not guilty. Maybe equals not guilty. This is not a court of public opinion. This is not a court where special interest groups tell you something. Evidence matters here. This is not a civil courtroom where 51% is enough. Evidence matters here. Not politics, not labels. I'll tell you what. Why don't we all take a moment? Let's all take a moment to consider all of the credible, unimpeached evidence sufficient to convict David March. Okay, we're done. There's none. This innocent man sits here, and there's been no credible, unimpeached evidence sufficient beyond a reasonable doubt to convict him. The state's case is so weak. The absence of real credible evidence is so apparent. You must, as a matter of law, find David Marks not guilty. And here's something that I don't think the state realizes. David Marks wasn't there that night. He didn't see it. David Marks has no personal knowledge of what happened that night. He's assigned to investigate, and his investigation begins by talking to the people who were there that night. He has to accept what these witnesses tell him, and he writes it down. And like I told you earlier, and I renew my arguments I made at the close of the state's case, so I don't repeat them now. But he's merely a reporter at that time. He doesn't judge, he doesn't edit. He can't say, stop, I don't believe you. Here's what I'm really going to write down. He can't do that. As a matter of law and duty, he's duty bound to write down what the witnesses tell him, whether he believes it or not. In addition to learning about the case by interviewing witnesses, he's in charge of collecting all the evidence in the case. He oversees Carl Bracing and Kamal Judah arrive at the scene and process that crime scene. David Marks makes sure every one of those shell casings is collected. That knife that is clearly on the video that they don't want to talk about is collected. David Marks' duties include not just talking to witnesses, but making sure there's a complete and thorough investigation. And he did that in this case. He's trying to talk to witnesses. He's making sure the evidence technicians do their job. He's finding out from the hospital what time McDonald was pronounced dead. He's dealing with not one, but 4 IPRA supervisors who were on the scene that night, as you see from People's Strike Act, March's Exhibit 8 and 9. He's dealing with the deputy street superintendent in charge that night. He's spending hours at the scene. And his investigation doesn't stop there. It continues for months. The state says David Marks was framing this narrative that night. Nothing could be further from the truth. The reports that they rely on, she forgets to mention, they're not submitted till March 15th of 2015. They're not written that night. Talk again about Dora Fontaine. And again, I renew my arguments about Ms. Fontaine. Counsel says she has no reason to lie. That's wrong. She actually has 90,000 reasons to lie, along with some benefits. Your Honor, as any trier of fact, can judge the credibility of a witness. And in doing so, can judge her manner while testifying, her demeanor, her reasonableness of her testimony in light of all the evidence in the case. You can consider her interest, her bias, and motive, which is apparent in this case. And you can consider, without limitations, her prior under oath testimony as substantive evidence. When she told an inspector general on March 16th of 2016 that McDonald was making attacking movements, when she told that same inspector general under oath on March 16th that she doesn't recall telling David March that one line, she might have, you, Your Honor, can consider those under oath statements as if she said it in this courtroom today. It's substantial impeachment, which calls into question her credibility today. Take a look. Let's take a look at what Ms. Fontaine said. She admitted everything to David March in this courtroom except for one line. One lousy line. And I counted all of the documents that David March created and we submitted in this case. All of David March's GPRs, single space. All of David March's supplementary reports, single space. Every inventory sheet, every evidence submission form, every memo, every document he produced in this case, I lost track at 106 pages. And they have the audacity to tell you that David March committed a crime, if you believe Dora Fontaine, by the way, that one lousy line in 106 pages is official misconduct and obstructing of justice. You gotta be kidding me. They want to criminalize police reports. Well, you know, Judge, not just in this county, but in every other courtroom in the United States, we don't give police reports to juries and tell them, here, have them. Go read them in the back, knock yourself out, come on back and tell us what you think. That's not how trials are done in the United States. Police reports are summaries. They are not evidence. They want to convict David March because of one line in all the police reports he wrote. And that's if you believe Dora Fontaine, and you shouldn't. Assume for the sake of argument that Dora Fontaine was telling you the truth when she said, I did not tell David March, the offender ignored, raised right arm toward Van Dyke as if attacking Van Dyke. Let's assume she didn't say it, and David March, on a whim, even though he never met this woman before, is like, yeah, I'll just write it down. Well, guess what? That is nothing more than what we call impeachment. A witness says something in the courtroom that isn't in the police report, impeachment by omission, or the witness comes off saying something that is in the police report, impeachment by prior inconsistent statement. That is all this is, if you even believe Dora Fontaine. That's not a crime. But let's talk about this one line from 106 pages. The offender ignored the police commands. Well, whether Ms. Fontaine wants to remember it or not today, that fact is true. He was ignoring multiple police commands to drop the knife. That's true. And all Dave wrote was, McDonald raised his right arm. Again, I must renew this argument because Ms. Holmes, in questioning Ms. Fontaine, she even lifted her arm over the shoulder. And she's asking Fontaine, did he raise arm over shoulder, overhead? Did he charge? Did he attack? Did he touch? Dave March didn't write any of that nonsense. They want you to think just by body movements from the prosecutor asking the question, Dave March wrote it. He didn't. This is complete nonsense. And then, the last part, raised arm towards Van Dyke as if attacking. Now let's think about that for a second. As if attacking? Huh? Well, you know, Judge, on March 16, 2016, while under oath, the same oath he took in your courtroom, Fontaine said McDonald was making attacking movements. Not as if he was making attacking movements. He was making attacking movements. You can consider that as substantive evidence today. But if Dave March wanted to, frame the narrative, as they keep calling it, why put that in as if attacking? Why don't you just say, he raised right arm and attacked Van Dyke. He raised right arm over shoulder and attacked Van Dyke and charged Van Dyke. Just write it. And then you've got to ask yourself this question. David March with all of his experience and his dedication to law and order, if he was going to frame the narrative as they keep throwing out there, do you think for 1 second he's going to pick Dora Fontaine, a person he's never met, and then rely on her backing him up in this so-called conspiracy? You got to be kidding me. That's nonsense. Take a look. Let's take a look at the police reports. That speaks volumes about the state's case and how much they don't get it. Would you please put up Fontaine's report and go to page 4? Fontaine case incident number 1. Please highlight David March's line. Thank you. Let's take a look at this. At the beginning of the case, while Ms. Fontaine was on the stand, they were trying to insinuate that David March reviewed this report and approved this report, and that's why his name is on it with his personal PC number. Well, that's wrong. And you know that, Judge, because Nancy Pekarsky-Black told you that she put David March's name in Fontaine's report, because the next day at 15:01 hours, when she's creating March exhibit number 7, he's assigning David March's name to the Fontaine report. When she's on her computer and she enters David March's star number, and it populates everything else in the Fontaine report. It put in Dave's star number, employee number, his name, his PC number. And the exact same time, 15:01 is the exact same time that Nancy Pekarsky-Black is preparing her report on that very same computer. She put David March's name on Fontaine's report. And like you caught, there's no evidence that March reviewed this report, approved this report. And now we learn today that March can't even access this report to change any information. He can print it the next night, but he has no ability to change the information in the report that Fontaine prepared. And what does Fontaine put in her report that she blames Dave March on now? Well, the report says Van Dyke was injured by a fender. Well, when you put in March case report, it's the same report, it's the first stuff.
Case up 1.
Case up 1. I'm going to direct your attention, Your Honor, to March exhibit number 8, which is also known as March case up 1. It is submitted by David March on March 15th, 2015 at 18:23 hours. That's, I don't know the math, but that's a good 5 months after this night Dave decides to frame the narrative. But be that as it may, you go through this report and 2 things stand out. One, Dave March lists 4 victims. Tom Gaffney, Jason Van Dyke, Joseph Walsh, and Joe McElligott. 4 victims. Fontaine only had 3. That doesn't sound like much of a conspiracy. They can't get the number of victims straight. But then there's something else, Judge, that is extremely, extremely important and flies in the face of this ridiculous theory of theirs. Please go to page 2. That's page 3. Page 2. Page 2. Scroll up a little bit, please. That's good. Right above Laquan McDonald's. There's nothing about no injured by offender. In the Fontaine report, right above Laquan McDonald's name, there was injured by offender. Not in Dave March's report. And if you look at every one of Dave March's subs, he never writes Van Dyke was injured by offender. You know what that means, Judge? That despite Fontaine's ridiculous allegation that Dave March told her to be injured by offender, Dave March refused to put that in any of his subs. And nowhere in any of his hundreds of pages, about 100 and plus pages, nowhere does David March write injured by offender. Nowhere. She lied to you about that, Judge. Please turn. 12. And if you look at Dave March's sub, under the category injuries, Dave March writes down no injuries to any victims. The 4 victims he listed, none. The reports they tell you suggest David March is lying, fly in the face of that theory. He's correcting Fontaine's mistakes. And then, Judge, let's talk about what interaction happened between Fontaine and Dave March that night on the street. And in doing so, Judge, I refer your attention to Dave March Exhibit 57. It's a general order regarding preliminary investigation. It's General Order G04-01. And it states in paragraph 12 that for police-involved shootings, the Detective Division will retain responsibility for the department's preliminary and follow-up investigation anytime a police officer shoots or shoots at an individual. Note, in bold letters, the member responsible for the initial case report will report all factual information, victim, witness, offender, location, etc., within the boxes on the case report. The narrative will state, quote, for narrative and investigative details, refer to the Detective Division supplementary report filed under this Records Division number. That's RD number for Mrs. Fontaine's purposes, who didn't know what that meant. Dave March read that general order. There was nothing unusual. There was nothing wrong with Dave March talking to Fontaine about who the victim is, who the offender is, what's the RD number, where's location. That general order directs Dave March to do exactly that with Dora Fontaine. They don't want to talk about that. Thank God we're in a courtroom. Earl Briggs. Earl Briggs is a incredible witness to say the least. I'm going to be kind. And I support this with March Exhibit 3 and March Exhibit 3A. Both reports prepared by Mr. Briggs. Both reports, let's write that. One report signed by his supervisor, Mr. King. One report not. Both reports purport to document information received by Mr. Briggs from David March. Yet, lo and behold, the reports are different. Things have changed. What in God's name is happening at the medical examiner's office? Mr. Briggs wants the world to believe that Dave March is telling him that the offender lunged, right there, the subject lunged at the police officer. Well, hey, Mr. Briggs, Did you put the word lunged in quotes? No, we didn't. Yet he puts in quotes the phrase Chicago police officers. The officers announced their office as Chicago police officers, closed quotes. Really? Do you think for 1 second that McElligott and Gaffney and Walsh and Van Dyke and any other uniformed officer out there was saying, stop, Chicago police officers, that's baloney. And if you're going to put Chicago police officers in quotes, you better put lunged in quotes, Mr. Briggs. The means of identification of Laquan McDonald, completely different in Briggs's report. Briggs is claiming that March is giving him zip codes and locations. That's nonsense. Briggs is claiming that he reads back the narrative to David March. And in doing so, he claims David March said on or about October 19th. That's baloney. Lawyers talk like that. Not a detective from the scene of a shooting. And by the way, it happened on the 20th, not the 19th. If he really read it back, David March would have said, hey, you got the date wrong, Briggs. But here's the best. Here is the best. Dave March is still at the scene. As you know from the GPR regarding the phone call he received from the hospital and the pronouncement of death by Dr. Pitzel from Mount Sinai, not Dr. Digtel, as Briggs writes down, Dave March is telling Briggs about McDonald dying at the hospital. Briggs wants you to believe that Dave March is telling him where all the injuries are on McDonald's body. The arms and legs and the chest. Dave March can't possibly know that information. Briggs lied to you when he's claiming to you that information came from David March. That's a lie. You know where Briggs got the word lunch from? When he's watching Pat Camden's news conference, just like Jose Torres. Jose Torres had no problem remembering where he heard the word lunch from Pat Camden. And just like Mr. Maris told you, Camden is an FOP spokesman. He's not a Chicago police officer. He doesn't represent the police department. He's a media guy. And better yet, George, and this is the real proof, the real evidence in this case about this nonsense regarding lunch. Every one of the 106 pages written by Dave March in this case, nowhere in those reports does David March use the word lunged. Nowhere. If David March told Briggs the subject lunged at the officer, you'd see it at least on one page of one of those reports. No witness told David March that McDonald lunged. David March didn't write it, and you can take it to the bank. He didn't say it to Briggs either. That's a lie. Jose Torres. Can we see the Dunkin' Donuts video, please? This is the Dunkin' Donuts video. It shows Pulaski in front of Dunkin' Donuts, westbound perspective. Stop right there. Thank you, sir. You see the police squad car stopping, and you see Officer Walsh about to get out of that SUV. Van Dyke seems to follow. Take a look. The curb on Pulaski that's closest to you regarding Walsh's SUV, there's no car anywhere parked on that curb. Jose Torres claims he's only 2 car lengths away. Jose Torres is mistaken. Can we now see the video of 823 Robert? No, 813 Robert. Well, excuse me, 823 Robert. 823 Robert dash cam Robert. It's a dash cam video from another officer responding to the scene after the shooting.
Which video did you say?
It's
823 Robert.
823 Robert.
Okay, thank you.
Could you back up a little bit, sir? And I'll tell you to stop at the right point. Stop. Up ahead, you see some police lights. 1, 2, 3 vehicles parked on the east curb. Please continue and get ready to stop. Stop! Torres told you, in no uncertain terms, he was the second car in line. There was somebody up ahead of him. This building that I'm pointing to on the east curb is focal point. Dunkin' Donuts is further north. The shooting was across from Dunkin' Donuts, even a little bit north of Dunkin' Donuts. If what Mr. Torres is telling you is true, in that he was the second car curbed, you take a look at the distance from where this car, presumably Torres, is from the shooting. Please run it. Stop. You can see McDonald from a distance here. Please continue. Stop. Torres told you he's 2 car lengths away. That's a lie, or he's mistaken. But how ironic is it, Judge, for the prosecution to believe Jose Torres, even though his story flies in the face of the video, yet they charge these 3 men, claiming their reports fly in the face of the video. It can't have it both ways. That's reasonable doubt. And why do they call Torres? Because presumably, David March is responsible for interviewing Torres. The problem there is David March is a human being. He cannot read minds. He cannot identify anybody that will not come forward to him. He cannot even identify anybody that will not come forward to any police agency. Forget about the Chicago police. If Mr. Torres really is an eyewitness, don't just stop at talking to IPRA and then some agenda-driven reporter. How about calling the Cook County Sheriff's Police, the state's attorney's office in Cook County, the U.S. Attorney's Office? How about pick up the phone and call the FBI? They want to blame Dave March because he didn't interview Jose Torres? Not fair. Dave March would love to interview Jose Torres. Jose Torres will not let David March know who he is and where he's at. That's not against the law. Thank you. The emails. The emails are a complete joke. If what Ms. Holmes is telling us, if these emails are truly statements of co-conspirators made in furtherance of the conspiracy, if that's true, then Ron Haskell from the Law Enforcement Legal Defense Fund in Washington, D.C., and FBI agents, and Tony Wojcik, and Dan Gallagher, and Lieutenant Ozzie Valdez, and everybody else in the chain of emails that are made after Dave March submits the reports, then all of those people should be sitting over here too. Aren't they reports? Aren't they writings made by co-conspirators in furtherance of the conspiracy? If what they say is true, these people should be sitting over here too. I know you don't have a big courtroom here, but get those bodies in here if you really believe these are co-conspirator statements. And the fact that they're not here means this isn't a conspiracy. These emails are a joke. And Dan Gallagher's email, it's to himself. And all the other emails, they're after Dave March submitted, except the one from Tony Wojcik to David March, telling him language for that concluding paragraph, showing him all McDonald's arrests in his criminal history. We all have supervisors wherever we work. And sometimes we give them our work and they throw it back at us and tell us, correct this, change this. Lawyers will write briefs, submit it to their supervisor, submit it to their partner, and it's brought back, change this, change that. That's work product. That's not co-conspirator statements. And anything done between Ron Haskell and Tony Wojcik months later, and an FOP spokesman named Tom McDonough, well after David March submits his reports, that's nothing more than people rallying to the defense of one of their own in law enforcement. There's nothing wrong with that. But even if there is, Judge, even if there is, nowhere on those emails you see Dave March's name. He's not a party to this. Show me an email Dave March wrote. Show me an email Dave March got a copy of regarding these ridiculous emails months after the fact. While Dave March is at the scene and the evidence technicians are collecting evidence, one of the pieces of evidence they found, Judge, was a knife. And it was measured by Carl Bracelet as the report indicates. And it's in March Exhibit number 8. And we know that that knife was 7 inches overall with a 3-inch blade. Well, you know, Judge, based on the law, based on Illinois law, a knife with a 3-inch blade or greater is a Category 2 dangerous weapon. 720 ILCS 33/A-5. That's a dangerous weapon. They don't want to talk about that. But these officers that were out there that night, they had to deal with it. These human beings, with their hearts pounding in their chests, with fear in their minds, with the unknown about what this crazed guy was going to do after all the things he did that night, they have to be aware of that dangerous weapon. And everything that makes those officers human beings, you must consider when we talk about whether these reports are false or not. Remember, Judge, the goal of the conspiracy, as they have charged, is that David March and others agreed with one another to perform acts to do two things. Shield Jason Van Dyke from other independent police agencies and shield that video from the public. Where is the evidence that these police reports, not just David March's, all of the police reports in this case, where's the evidence that these police reports hampered the investigations done by IPRA, the Cook County State's Attorney's Office, the FBI, the U.S. Attorney's Office, or the Inspector General? Where's the evidence that these reports they claim are so evil? Where's the evidence that those reports hampered those investigations by those separate independent police agencies? There is none. There is none. And it begs the question, where's the evidence of the agreement? No evidence that David March even met these two gentlemen or anybody else that night, and they got together, even implied, and said, hey, let's get our story straight. Let's help Jason Van Dyke avoid being prosecuted or investigated, or we'll even obstruct his defense. That's how it's charged, as ridiculous as that is. And let's talk about that. Because even Dora Fontaine, who has all the reasons to come to court, lied to you, even she admitted, nobody's at the area talking about the case. Joe McElligott said the same thing to you under oath. Where's this conspiracy?
Is there an objection or not?
There is, that's not what he said,
I
that they
heard
were.
this. I heard this.
All right, with that.
Where's this conspiracy being born at the area? By the way, there's no evidence that Dave March is at the area when this conspiracy is being born. He's still doing his job at the scene. And let's talk about just due process, fairness, which our laws rely on. Our criminal courts mandate is in every case. Let's talk about this. David March is the person responsible for inventorying all of the videos in this case. And you know that from the exhibits we submitted in this case, Your Honor. Group Exhibit 38. You know this from all of these inventory sheets that David March produced. He's saving video for you, for them, for the world. How fair is it, Judge, for David March to be sitting here and the evidence he saved is being used against him? The evidence they rely on, that he kept, he preserved, memos are directed downtown to Mr. Perfetti's office. Save this stuff. How fair is that? And in addition, you heard the final stipulations offered by David March today. You know now that David March testified twice in the Jason Van Dyke case. You know now, on June 28, 2017, and on October 8, 2018, David March testified. He was called by the prosecutors in that case. First time was live testimony. The second time was by way of stipulation. But you know now, Judge, that the prosecution in one courtroom relied on Dave March's words.
That just is a totally improper argument. The idea that
I don't need any further argument on that. It's sustained.
The prosecutor called David March and did not attempt to impeach him.
Objection. That's sustained. There's no evidence of that, Mr. McKay.
It is unfair for David March to be sitting in this courtroom and his words are used against him now. They can't have it both ways. And what are we talking about here? We're talking about words. Like I said, David March has no personal knowledge. He wasn't there that night. So his words, not the words of the people he interviewed that he documents, his words come down in two places. His words, which are found in March Exhibit number 9, are as follows. His words, that the recovered in-car camera video for beats 845R and 813R was viewed and found to be consistent with accounts of all of the witnesses. The second thing he said was his closing paragraph, which reads as follows. The above to-date investigation determined that Laquan McDonald was an active assailant who, while armed with a dangerous weapon, used force likely to cause death or serious injury to a private citizen when he attacked Rudy Barillas, threatened the imminent use of force likely to cause death or serious injury when he incised the tire and stabbed the windshield of a Chicago Police Department vehicle occupied by Officer Thomas Gaffney, and initiated imminent use of force likely to cause death or serious injury when he initiated an attack on Officers Jason Van Dyke and Joseph Walsh. The above investigation concluded that Officer Jason Van Dyke's use of deadly force to discharging of his duty firearm was within the bounds of Chicago Police Department's use of force guidelines and in conformity with local ordinances and state law. Let's talk about the first one. The first one is the recovered in-car camera video from beats 845 Robert and 813 Robert was viewed and found to be consistent with the accounts of all the witnesses. Your Honor, because David March has no personal knowledge, because he conducted an investigation that spanned from October 20th, 2014, until the day he submitted this report on March 15th, 2015, that statement is his opinion. It's an opinion. They want to criminalize a person's opinion. We don't do that in the United States of America. And it's an opinion, Your Honor, that's based on experience, the collection of evidence, every aspect of this investigation, from Rudy Barillas to the lab that analyzed the PCP in McDonald's veins. Everything in this case helps support his opinion. Now, Your Honor, somebody can disagree with that opinion. Heck, Your Honor, you can disagree with that opinion. But it's not a crime. Even if you disagree with the opinion, it's not a crime. It's a disagreement. Educated people disagree with each other all the time. Lawyers disagree with each other all the time. I disagree with everything Ms. Holmes just argued. One of us must be lying then. Judge, David March rendered an opinion. He wasn't there. He can only rely on everything he learned. That's not a crime. And by the way, he wrote, the in-car camera video is consistent with all witness statements. Consistent. Not identical. Not matched. Consistent. Experts come into our courtrooms all the time, and based on the information they're given, they render opinions. Kind of like a medical examiner who says, hey, the gunshot wound is consistent with the victim's standing. Or the gunshot wound is consistent with the victim attempting to defend. The trier of fact can accept it, but it's merely an opinion that's only consistent. Even the opinion, that's right, that even the person rendering the opinion may not rule out other possibilities. It's not a crime, what Dave March said. And his opinion is based on not just the video, which Mr. Snelling based his on, completely just limited to the video. Dave March based it on everything in this case, including Illinois law. And regarding the concluding paragraph, that too, Judge, whether it's formulated with Tony Voljic, his supervisor, or not, it's an opinion. The above to-date investigation, this investigation has spanned 5 months, determined Laquan McDonald was an active assailant. Well, guess what? Even Dora Fontaine said McDonald was an assailant. That McDonald was an active assailant armed with a dangerous weapon. Illinois law tells you that's a dangerous weapon. It's interesting, when they put up Dave March's concluding paragraph, they highlighted in yellow everything except this sentence. That McDonald used force like to cause death or serious injury to a private citizen when he attacked Rudy Barillas. Why did they highlight that, Judge, just a few minutes ago? Because they don't want to talk about Rudy Barillas. They don't want to talk about an innocent civilian who called 911, who needed the police to come and serve and protect him and his wife. Dave March interviewed Rudy Barillas, as you know from the exhibits we submitted to Your Honor. Dave March talked to that man. You know from the other GPRs, detectives working with Dave March talked to Yuli Garcia. Rudy Barillas, was a victim of an aggravated assault, a victim of an attempt murder. And by the way, you know, Judge, that when McDonald was breaking into trucks, that's a burglary. And under Illinois law, you know that's a forcible felony. Now, Van Dyke doesn't know about Rudy Barillas, but Dave March does. When Dave March writes that 5 months later, Dave March can base his opinion on the Rudy Barillas attack and the forcible felony of burglary. In addition, Dave March talked to Gaffney, McGilligan, Walsh, Van Dyke. He did view the video, and every other police officer out there, he talked to them as well. He reasonably concluded in his opinion that's based on 30 years of police experience that those officers that he listed, not Fontaine, that he listed were victims of aggravated assault. That's a forcible felony when the victim's a police officer. They want to criminalize Dave March's opinions. They can disagree with them. Anybody in this world can disagree with them, but that's not a crime. We cannot and should not criminalize free speech in this country. And you know, from March Exhibit 5, the General Order G030203, which is based on Illinois law, specifically 720 ILCS 5/7-5, when a peace officer can use force in making an arrest, and when he can use deadly force. And you know, Judge, from Illinois law, that an officer is justified in using force likely to cause death or great bodily harm only when he reasonably believes that such force is necessary to prevent death or great bodily harm to himself or such other person, or when he is reasonably believed that both that such force is necessary to prevent the arrest from being defeated by resistance or escape. Everybody keeps saying McDonald's getting away. Torres even admitted after impeachment by Mr. Pugh that McDonald's trying to escape. And the person to be arrested has committed or attempted to commit a forcible felony, like burglary, like aggravated assault against a police officer, like attempt murder of a truck driver named Rudy Barillas, which involves the infliction or threatened infliction of great bodily harm, or is attempting to escape by use of a deadly weapon, or otherwise indicates he will endanger human life or inflict great bodily harm unless arrested without delay. Nowhere in the video do I see McDonald dropping the knife and submitting to an arrest. Nowhere do I see that. Let's play the video, please. Let's see the dash cam video. Thank you. Watch this. Stop. Stop. We have just been told, we Officer McGilligan, and we saw videos, that McDonald is running down 40th Street. But when he gets past the Burger King, after he runs to the Burger King lot, he gets in on Pulaski. What does he do? He then slows down. What does that tell a human being like Joe Walsh and Jason Van Dyke and everybody else out there? He ain't running away anymore. He's slowing down. Why? He's preparing to engage. And then he does this. He's pushing. Flips the knife. Stop. He's showing that knife to these officers. He can clearly see. He's showing that knife. He's getting ready to engage. And please continue. Stop. What you're about to see next, yes, he's on the dotted white line, but then he begins to walk parallel on that dotted white line. Is he heading in a southwest direction? Maybe before, but not when he gets to the dotted white line. Is he advancing towards the police officers? And the answer is yes. Yes, he is. Walsh and Van Dyke are coming towards him, but McDonald's not stopped. As McDonald continues to walk in that direction with Van Dyke as McDonald's walking in that direction and Van Dyke and Washer are coming on an angle, the distance is closing. What does McDonald do? He's got a great opportunity to do a couple things. One, how about drop the damn knife? Or, how about this? Take a hard right. You want to get away? Go opposite of the officers. Go in this direction towards this fence. Or drop the knife and run that way. If he drops the knife, these officers can't use their gun. But these officers can only perceive what's happening in front of them. But the law says, even if he's trying to escape from that forcible felony, the officers can use deadly force when he's still armed and he's using that knife to effectuate the escape. If he's not, then what the hell is it doing in his hand? Thank you. They don't want you to accept the fact that McDonald's committing aggravated assaults. They want you to believe that this is a homicide investigation. They refuse to ignore the crimes that McDonald is committing that night. The police officers can't. David Marks can't. It's his job to investigate everything that happened. He has to consider aggravated assault after he's talking to Gaffney and Walsh, after he talks to Rudy Varillas. You know the law of aggravated assault. You know the elements are there. You also know that McDonald doesn't have a right to do what he's doing that night. Because you know Illinois law says a person is not authorized to use force to resist an arrest, which he knows is being made either by a peace officer, even if he believes that the arrest is unlawful and the arrest is in fact unlawful. He has seen uniformed police officers from 5 blocks away with McGilligan and Gaffney. He's running past a Burger King. He's on the middle of Pulaski. There's police cars everywhere. What does he do? Does he submit like most people will? At that point, no. He slows down, flicks that knife, the underhand grip across his chest, swinging or swaying, however you want to describe it. That's what he's doing. That is criminal conduct that the officers are perceiving and that Dave Marks knows throughout the course of his 5-month investigation. The medical examiner report, as submitted tonight, March Exhibit 37, lists all the gunshot wounds. One of them, number 4, is a gunshot wound to the right chest. The direction is front to back, left to right, and slightly downward. That's consistent with facing the shooter. And by the way, if McDonald was really just trying to get away, doesn't it make sense that all the gunshots would either be in his back or on his side? You look at this protocol by Dr. Means. You see where those entrance wounds are. They're not all on the back and on the side. Most of them are in the arm with that right hand that never releases that knife. And just like Jose Torres told that IPRA investigator under oath will be recorded, it looked like McDonald was trying to get up. That under oath statement by Torres can be considered by you as if he said it here today. Exhibit 48 is a document, 2 documents signed by David March, making sure that all this dash cam video is preserved and permanently retained. The special prosecutor should be thanking David March. Thank God we are in a courtroom. Thank God we are in a place that evidence matters. Not just words out there in the public without a shred of evidence to support. Evidence matters in this courtroom, Judge. The state has failed miserably in providing you evidence you need to convict any of these men. With the burden of proof and the presumption of innocence, you need clear, convincing, compelling, strong, unambiguous evidence to find these men guilty. You have none of that. You have none of that. You have heard all the evidence in this case, Judge. You have heard my arguments I made the other night and my arguments again tonight. David March sits before you, an innocent man, a professional committed to law and order, a professional who did his job, who wasn't there and collected all the information he possibly could. And he wrote 106 pages. And all they come up with are 2 lines regarding his opinion and 1 line Miss Fontaine is coming off of now, when she never came off it before, even under oath. That, Your Honor, is not proof beyond a reasonable doubt. Do not criminalize opinions. Do not find words amount to a crime. There is no evidence of an agreement, no evidence of a conspiracy, no evidence that Dave March was trying to shield Van Dyke from any of these other agencies that did conduct investigation of the case. No evidence whatsoever that Dave March had any authority to hide video from the public when he stated it. There's no evidence of any intent on David March's part to obstruct anything, much less obstruct justice. There's no evidence of any intent that he committed official misconduct. They must prove to you the mental state for all of these crimes. They have failed miserably there. The evidence is so lacking in this case, Judge. You must find David March not guilty. You must find this innocent man, David March, not guilty.
Thank you. Mr. Brainer, Mr. Pugh?
Your Honor, I'm going to ask for a brief recess, but before I do that, I would like to adopt our arguments on the motion for a directed finding.
Certainly. And Mr. McKay, you did the same on yours as well?
Thank you. Yes, I did.
Okay.
And at the close of the case, Judge, both sides move again for the motion for directed finding. I assume you did that.
Same argument, right?
Yes.
Same ruling. Motion for, I'm not even going to ask for argument again from the state. I'll just consider the argument that you previously made as taken if you're adopting that same argument.
Yeah.
Okay, that's your motion for directed finding is denied.
Judge, with the understanding that I will be relatively brief, could I bargain for a 5-minute recess?
You could argue as long as you want. I haven't put restrictions on
I know
the
you
parties, but yes, we can take a recess. Is 5 minutes okay, or 5 or 10?
That's fine with me, Judge.
Okay. Mr. Beatty, will you be prepared to do closing arguments today?
Yes.
Okay. And will the state be prepared to do a rebuttal,
Yes.
if any? Okay. Then let's take maybe a 10-minute recess. Did you have something else, Mr. Beatty?
Judge, I, at this point, just, we're discussing it. I would also review my motion for directed finding of not guilty and rest on my
I join in that, Your Honor.
Okay. And I will adopt the state's argument from that as well. And the motion for directed finding, your review motion is denied for all defendants. 10-minute recess.